My name's Dusty Otwell. I'm the lawyer in this course. I like all the lawyer repellent stuff in the pictures of the seminar or the lecture before me, and then send up the lawyer. So I'm the Vice President for Claims and Risk Management at U.S. Acute Care Solutions. I, at any one time, am juggling a few hundred cases, litigation as well as potential cases. I've been doing this for a long time, and the cases that we see give me a pretty good idea of what it takes to keep you out of hot water, and if you end up in hot water, what it's going to take to get you to survive that experience. And Ross touched on, giving you the confidence in this space of malpractice litigation, and that is my intention for you in this course. Some of these courses, it's all about, here's the nightmare of litigation, here's what you need to be afraid of. Now, fear can be a motivator as long as it leads to a positive improvement. And we, at this course, are about giving you the confidence to go back to your shops, understand the reality of the risk and malpractice that you deal with in ER medicine, and then take better care of your patients, and take better care of yourself, keep yourself out of hot water, and if you do, survive that experience. And to illustrate what I want for you out of this course, I'll tell you a couple stories. I was at the Paris a couple of years ago when I first started in on this course. And there was a gentleman at the conference. I wasn't doing the conference yet. I was just kind of learning the ropes. And there was a gentleman who asked a lot of questions. And the kind of questions, you're at a conference, somebody's asking all the questions. You kind of tell, okay, something's going on with this person. They're not having a great time. And so we got through the conference, and then we went out to the bar. Well, I did, by myself. And it was the bar in the middle of the Paris. And I looked over, and I saw the guy. And this is what I saw. So he was obviously going through some things, and I was very interested for the purposes of coming on as faculty in the course. So I went over there, asked if I could buy him a drink, and just kind of picked his brain. And he said, this course has just terrified me, and I don't know if I can go back to my shop. And we got to talking, and there was a lot of other things going on, financial, his family. His life was not going great, but the course had an impact on him that I think will possibly lead to, or be one of the many factors that lead to him not practicing medicine in 3 to 5 years. Because he just took so much fear from the course, fear from the risk of malpractice, and it just informed all of his kind of terrified reactions. And I don't think he went back to his site with a lot of confidence. Rather, I'll tell you the story of Admiral Stockdale. Now, some of you might remember this is the guy who was the vice president candidate with Ross Perot, and that was kind of a bit of a circus. But he was a true hero, before that. And what it came from was in the Vietnam War, he was shot down in Vietnam, one of the earliest prisoners of war. Not only did he survive that experience, he thrived through that experience. He was a real leader in the POW camp and saved a ton of lives. And then later on, they interviewed him, and they said, what made you different? What made you survive and thrive in that situation? And he said, well, there were kind of 3 camps of individuals that came into the prison. There were the optimists, the ones who said, we're going to be out of here by Christmas. They're going to bust us out. This is going to be, no big deal, fellas. Well, they didn't survive because reality caught up with them, and eventually it just dragged them down. And then the alternative, there were the pessimists, the ones who just really dove into the negativity of the situation. And, the situation accommodated their negativity, and they went down a dark hole and didn't survive. In ER, I think the pessimists are probably the more likely candidates when you're describing the ones in your shop reacting to change or malpractice risk. This isn't fair, this is BS, these plaintiffs' lawyers are just, bilking the system, and yeah, that might be true, but if you just dive into the negativity and the fear of the situation, you're not going to gain that acceptance that leads to confidence. So that's an illustration of, in this course, this is about gaining full acceptance about what malpractice risk is all about. In your state, in your individual environment, at your shop, what the risks are. Really swallowing them deep down, just like he did in a POW camp, so that you can then use your intellect, your training, to create small gains and have confidence that you're going to be okay in malpractice risk and then move on with your careers and take better care of patients. So it's about confidence, this course. I'm going to talk till about 9 o'clock with how to survive a malpractice lawsuit from about 9 to 9:30. We're going to have a mock deposition, tons of fun, and then I'll close in about 15 minutes with just some final points. So let's get going. I'm gonna get a little interactive. I want to kind of liven things up here. So who agrees with this statement? Who thinks, if I did it right, a jury's not going to find me liable? Does anybody agree with that? Anybody feel confident in the jury system? Anybody disagree? Anybody disagree? I saw a hand. Why? Why do you think? Why do you disagree with this statement? Yeah, it's about jury perception, individual perceptions. The jury perceptions are also very individual, not just to individuals, but geography, cities. Baltimore City is very different from Baltimore County. If you're in Texas or Virginia or California or New York, your malpractice environment is completely different based on the jury pool. The tort reform has an impact, but it's all about the potential jurors. It's not fair, it's not just, but it is what it is. Also, does anybody agree with this? Anybody feel like if I ever got sued, and I know I did it right, no matter what the insurance company, the group says, I wouldn't consent to settle. I won't consent to settle, and I wouldn't consent. Does anybody feel that way? Joel, what do you think?
Sometimes it's not easy to accept that something is better off just.
Yeah, there's no lighter, happy's not the word, but just relieved provider that I see when we walk out of mediation and the case has been settled. They might walk into the mediation thinking, this is my, catharsis, we're going to fight this to the ends of the earth, but then they realize, you know what, this is not worth it, and they settle, and then they move on. Some providers still feel this way. And I encounter them, and they say, I'm not going to settle, no way, no how. But usually approaching trial, if not mediation, they say, you know what, this is about risk, it's about financial risk, and it's just not worth it. It's not really any financial risk to them personally, but just the idea of having that verdict risk on your career kind of leads them to settle. And then finally, you all do this. Does anybody admit it? Or can we all admit we practice defensive medicine? Of course you do. Of course you do. Why do you practice defensive medicine? Anybody think, here's why I practice defensive medicine? One of the residents that care to opine on why one would practice defensive medicine? Or what do you feel about that? Think it's a good thing, bad thing? Safer? Safer. Safer to patients or safer to you? Yes, safer to patients or safer to you. I thought about, defensive medicine has a negative connotation, but, what if we thought defensive piloting of an airplane? That makes me feel kind of good. Defensive medicine, of course it informs your practice. Malpractice and the financing of it is designed to impact behavior. That's what ADA lawsuits are supposed to do. That's what drug lawsuits are supposed to do. They're supposed to impact the behavior of the people who got sued. So of course it impacts behavior. With that, we'll go into our first case study. So this is one of a couple we'll talk about this morning. But so this is a case, and we're going to walk through the resolution of this case. So you got a young man. He comes in, right lower quadrant pain. They do the exam, pretty benign, nothing worrisome. Order a CT, IV contrast. Back when this was pretty standard. And the important thing, he had a CT previously for a hernia with no problem. But then about a minute after the contrast, the patient starts seizing. The ER doc responds quickly, orders a dose of Ativan, which worked, and instructs the team, quickly complete the study and then get him back in the ER. And they do, but he starts seizing again. He talks to the parents, try to figure out what's going on here. He did that actually before the second seizure. Gave another dose of Ativan, but he developed flash pulmonary edema, and all this within about 30 minutes. transferred, and dies within the next few days. Dies of anoxic brain injury secondary to shock, secondary to the IV contrast. So we get sued for this. Now, in any suit, you've got strengths and weaknesses. Strengths and weaknesses from a clinical sense and a non-clinical sense. Now, starting with their theory. So, you should have noticed this anaphylactic reaction. You should have given epinephrine, should have aborted the CT, and you should have intubated faster. Now, these look bad, but, we have our own strengths as well. Now, go back. Clinical strengths, non-clinical strengths. Non-clinical strengths in this case, you got a sympathetic plaintiff. A child, a young man dies, that always just stinks, and people respond to that. This was a case that had publicity. That was a tragic case, and sometimes the newspapers pick these cases up. The newspaper actually still has a pretty significant impact on malpractice litigation. Newspapers are apparently still around, and sometimes they pick up these malpractice suits, and it really kind of freaks out the hospitals, and it can kind of drive some behavior. And the parents in this case, they weren't weasels, they weren't greedy, they were just trying to find some answers. But we had our own theories as well. We had a good theory defense. He had never had this kind of reaction. Probably wasn't an anaphylaxis. Epinephrine was actually a bad idea, given that he had a high blood pressure at that time. And when an intubation was finally necessary, it was quickly performed. We had our own strengths as well. Sometimes plaintiffs are very sympathetic, but oftentimes the defendant clinicians are very sympathetic. This one actually happened to be the local medical director, knew his stuff, was really likable, testified well. So, I've given you the very basics of this case. Let's do a show of hands. I'm going to pick on maybe some people. So what do you think? Do you want to settle? Do you want to throw your full policy limit at the problem and just make it go away? Who wants to do that? You're done today. Throw your whole policy limit and then move on with your life. Nobody? Okay, we want to maybe just get it over with. Are you APP or clinician? APP, okay. That didn't mean anything. Just ask some follow-up questions, just get my bearings here. What about around, $500,000, maybe a little less than that? Who's willing to throw 6 figures at this case, put it on your career, and make it go away? Who wants to do 6 figures? If you don't, you could be in for a bit of a ride. $25,000. Who'll take $25,000 to settle this case? No one? There we go. Okay. So the rest of you are all willing to go to trial and take a significant risk with a deceased child, and that's okay. We'll do that. We get paid either way. But before we do that, we really need to give you some very informed, basically informed consent discussions about what you're getting into if you decide to go forward with this case. Cases are all about money. Now, that might seem, like a no-brainer, but actually to physicians, clinicians, you go into a case all about the medicine, don't you? Was this standard of care or not? To the attorneys, we are putting this into dollars and cents immediately because that's what the plaintiff's attorneys are all about. They will respond to the financial incentives in the case. So you do some math. This is all kind of soft science. But you try to figure out, how likely are we going to lose? And if we lose, how much is it going to be? And to get these numbers, you can do a number of things, including a mock trial. A mock trial, you bring in some folks from around the area, pay them $50 and a pizza, and over an evening or a weekend, you do a very abbreviated trial. And we did in this case, and we won. However, they said you get to interview them, and that's the value of a mock trial. And they said, we really weren't sure. One person felt really strongly, so we were like, what the heck, we'll go with the physician. But if we didn't go that way, we would have given them $2 million. So now we can put it back into our calculus. So, you very well might win. But when it's 40%, I feel like, that's a coin flip. That's how I describe it to physicians or clinicians who are really trying to decide, do I want to go to trial or not? And unless the attorney tells me you have a 95% chance of winning, It's almost like when they were trying to figure out if they were going to go into Pakistan and try to get Osama bin Laden. Obama said, people were saying it's 60%, it's 90%, it's whatever. He said, well, he's there, he's not. That's 50-50. And in a trial, you're going to win or you're going to lose. And if somebody tells me 60, 70, 30, dude, that's a coin flip. Nobody knows. So are you willing to flip a coin, and if you come up bad, you might be on the hook for $2 million on your career? So let's go back through those questions. Now, who's willing to settle for six figures? Joel's in it. Joel's in it to win it. Okay, Joel's engaged, and he understands the game. My man here, he's engaged. Yeah, the residents are starting to change their minds. Well, in this case, we took it to mediation, and we settled for $300,000. You may be focused on trial. I want to learn about the trial. What's that all about? I've got maybe 150 live cases going right now. I will sit in a trial maybe twice this year. I will sit in a mediation much more frequently. Mediations are where really cases are won or lost. Won or lost in terms of successfully resolved or not. And mediations are this weird all-day thing. Has anybody ever been in a mediation? Yeah, we got a few. Yeah, Joel, you remember? Okay. Yeah, it was weird, wasn't it? Go in this conference room and start drinking coffee, and you just sit there for a long time while just this guy, this older judge, is running back and forth, working things out. So it's this awkward thing, but it's important for you to be there, important for you to be engaged and get a successful resolution, which in this case I would argue is a successful resolution. But you're not going to be engaged, you're not going to be with me if you're still answering all the existential questions in your head of why me. Well, litigation is not fair. It's just a fault-based system. This is not workers' compensation. If you get your foot cut off at Tyson Chicken Plant, no matter if you were at fault or they were at fault, you get this amount of money. It's a no-fault system. I believe Australia has a no-fault medical malpractice insurance system. But here, you have to assign blame in order to get money. And it's all about the financial incentives. In fact, they did a study which found that the behavior of the clinician was, comparatively irrelevant to the severity of the patient's injury, predictive of malpractice litigation and ultimate payment to that plaintiff. So it's all about those injuries and things that you really might not even have a lot of control over. And I illustrate with a case. So there was this case in which the care was fine. You had a septic child, delays, there was a long wait, there was an issue with triage, but just without getting into it, there was very diligent care by the ER providers. Got the patient treated, transferred. She survived, but she had multiple amputations. And so we get the demand letter from the plaintiff attorney that they signed up, and they put 24 pictures in there, and here's a couple of them. Remember, this is a fault-based system. You have to assign blame and get a jury to agree in order to get payment. You can't put that in front of a jury. It's not fair. The care was fine, but that just is what it is. And you should settle that case for policy limits, which is what happened. So if I can get you to, kind of step back from the clinical peer review focus of malpractice litigation and see it in more financial terms, it might not be fair, but you see the reality of the situation. And that's something that can have a lot of value for you in accepting what malpractice litigation is all about and doing what you need to do to protect yourself. It's just not a search for scientific truth. It's frustrating, but there's going to be experts on both sides. You'll have Dr. So-and-so from Virginia who says something completely different from the fellow we get from Johns Hopkins. And that is what it is, and those experts really will duke it out, and it's up to laypersons to decide who they believe. And a lot of times they're going to decide it based on things that have nothing to do with science, including whether they like you, whether they like the plaintiff, whether they're sleepy. So anyway, just kind of, if you can let that go a little bit, you're gonna defend yourself much better. Returning to those questions of why, sometimes it's just wildly unfair reasons, like your name was on the chart. I used to see, remember when there was those paper charts and you had that box up at the top? It was attending physician. It was always wrong. That attending physician was often the first one who was sued. And then we work it out, get him or her dropped, and then bring in the actual defendant. Doesn't happen so much anymore, but APP supervision, that's another way you can get brought into a case that you might be upset about. If you have to sign all the charts of your APPs, it could be that you get brought into a case. I've even seen a supervising, the collaborative agreement, supervising physician probably got brought into the case. One time, it wasn't the supervising physician, it was just the medical director of the site. And they put out this theory that the medical director of the site is ultimately responsible for the supervision of the APPs, and he was on the hook. So it's very frustrating when that happens, and we can get that supervising physician dismissed, usually, if they weren't really involved in the case. But it takes a long time, a lot longer than that physician wished it did. So, let's walk through a malpractice case. So it starts with, you just got sued. So when you get served, it will be a shock to the system. It does not arrive in a polite manner. The process server doesn't email you and say, hey, sorry to bother you, but we're suing you, and would any of these times be nice for me to come drop off the papers and have a cup of coffee with you? No, they show up at the department, or they show up at your front door, or they send you this weird letter. Sometimes even they do it through law enforcement in some counties, and it's just completely just terrifying. So you get these papers, and what do? Go find your insurance carrier, your risk manager. If you're not sure, ask your medical director, ask your hospital risk manager, ask somebody who looks like me, who's a lawyer type, what do I do, who has your best interest at heart. And if you don't, ask your immediate supervisor. You've got to get this in to the insurance carrier immediately. There's a lot of very short deadlines we have to meet in order to attach insurance coverage. The insurance companies don't want you to let these things linger. They want to know about the risk and attack the risk. Sometimes they can do something about it. And they put clauses in their policy that if you don't notify them within 30, 60 days, that could be a problem. But the thing I'm going to harp on is once you get it in, what do? You send it into an insurance company, it goes off into space, maybe they have a portal, maybe you call somebody and like the front desk kind of processes it. You put down the phone or you turn off the email. What do you do now? I tell you what you're going to want to do. You're going to want to go get in the chart. And you're going to want to text all your colleagues, and you are going to want to get on technology and solve this problem immediately. Because that's what you do as ER physicians. But this is not something you can solve intellectually. It's not something you can solve right now. It's not something you even should be accessing right now. Because if you go get in the chart, there's going to be a log you got in the chart. And there will then be a question later on of why did you get in the chart? And it just looks bad. So what you got to do is you get it in, and then remember me, and remember me saying, hey buddy, chill out. Go pour yourself a whiskey, some tea, go talk to your spouse, go into the lounge and just chill out a bit. And if I were you, turn your phone off and put it somewhere else. Because what I see is physicians in this world, they can do nothing about intellectually. They start to kind of get really anxious and they just want to do something to fix this problem, make this discomfort go away. And they get on text and they get on email, maybe even they get on Facebook and they cause themselves some problems. So you've got to find a way, starting right now in the life of this litigation, to cope, to survive, and to chill out. Because you're going to hear a lot of stuff that drives you crazy. Plaintiff lawyers say a lot of stuff, including, this isn't about money. They kind of craft themselves as these white knights, pursuing the interests of the downtrodden. Some of them are very professional, credible people that I enjoy working with. But if this were really true, they'd still be taking a lot of appendicitis cases for $25,000, but they don't. They take the big ones. It's all about money. They also try to put a guilt trip on you. they will talk about how bad of a situation the plaintiff is in and say, and you're telling me, they often give this argument to me, but Dusty, you're not going to give them any money. Look how bad of a time they're having. You can have empathy for your patients and for the plaintiffs, but it doesn't mean you are liable. I have great empathy for these patients and these plaintiffs. I mean, many of them, their lives were rough and their lives got worse because they got hurt. But having empathy for them is not the same as legal liability. So you can definitely feel bad for them, but doesn't mean you have to pay them money. One thing that'll drive you crazy is sometimes they will keep you in a lawsuit strictly for tactical reasons. Sometimes when things are in federal court, they'll keep a certain physician in there just to keep it in federal court. You're only in there for a technicality. Sometimes you had nothing to do with it. It was all radiology and surgery, but they're going to keep you in because if they let you out, everybody's going to blame you. And so they need everybody together in kind of one car and blaming that whole car to try to get the maximum compensation. So sometimes you're kept in strictly for tactical reasons. It's not fair. It stinks. But if you accept it, you can move on. A lot of times, they really feed into this, I think, common belief among folks that what you know is possible that can go wrong with the human body, people don't know. I didn't know until I got into this business, and people don't want to know. They don't want to know your heart can just explode. They don't want to know this infection can take your leg and maybe take your life, especially, if you're 20-something years old. They don't want to know about the extremely rare cases of risk, or 40 years old and extremely rare cases of heart attacks. So, because I think the public, myself included, doesn't want to believe, the body is so fallible, they think you should have fixed it. And they think you are infallible. And, TV and stuff has shown them that George Clooney can always save the day. And so that really feeds into the argument of, somebody must have screwed up. And then finally, plaintiff's attorneys will sometimes kind of get into, hey, doc, you shouldn't take this personally. But they really miss the mark on the extremely personal nature of this issue. You will not see a more intense interaction between two human beings than in a mediation where you've got the clinician and you've got the plaintiff. I mean, you can smell the tension from that room. It is extremely personal. I mean, a lot of times these people think that this person killed their loved one. And then the alternative, you got stuff like this that comes out of the lawsuit. This is just boilerplate stuff they put in every lawsuit. And I imagine you get your first lawsuit, you read through it 100 times because you're not chilling out like I told you to, and you're seeing these words, and it hurts. I mean, your entire character, your ethos is you are a physician. This was a calling, and somebody's telling you, you suck. I mean, that will really level you if you let it. Is anybody willing to say, hey, I got sued and I felt this way for a second? Yeah. If you get sued, you probably will feel this way. It is such a shock to the system. You're like, man, this ain't worth it. Doctoring is hard enough, and now I got that BS complaint with all those nasty things about me. I'm worried about, my career. I'm worried about my house. That's not a reasonable worry. That's not going to happen. But you have all these worries. You're like, you know what? This is not worth it. I'm going to go do something else. I'm going to be a lawyer. They seem to be having a good time. So it is a jarring experience the same way. I mean, if you do battle, if you're in a shooting, of course you're going to have psychological, mental, physical impacts from it. PTSD happens from litigation. Litigation stress syndrome is a real thing. Now, the rates of drugs and suicide for doctors and lawyers is already pretty abysmal. But when a physician, clinician is going through litigation, the risk of suicide doubles. So I joke about it, but I take it very seriously because I get really tired and I'm really impacted by I have defendant clinicians who just fall apart on me. And that's a problem for tactical reasons, because if they're not a strong witness, I need to settle the case. We're not going to win. And we could have had a better resolution if they didn't fall apart on me. Also, I'm in this because I'm inspired by the mission of caring for patients. But when these clinicians I deal with who just start to just lose fire for it, they just lose confidence, and their care suffers, their life suffers, it stinks to see people just kind of going in a downward spiral like that. So I take that side of things very seriously. The letter I got one time talked about how it just completely leveled him, psychologically, physically. And the thing about this that really hits me is it got worse every day. Every patient, he was more anxious about continuing to be a doctor. So this is normal, this is real, but this fella is not taking the responsibility for his body's reaction to the situation. And maybe he heard this old advice. This is old advice, and I want to debunk it. You will hear, if you get sued, don't talk to anybody, because those people could be called in to testify against you. The new advice, I would say, is just do what you got to do to get the support you need, because that will complement your defense. If you just hunker down and don't talk to nobody, but then come your deposition, you get completely thrown off because you're freaking out, well, that's not very good advice. Be mindful of the risk, sure. Now, if you go into the ER the moment you get your suit and say, hey, everybody, remember that case? Whew, I got sued on it. So what does everybody think? Glenda, what do you think? Linda, what do you think? Oh, you think I did good. Let's talk about that. Yeah, so those people could be called to testify against you, because in the deposition you'll see, I will ask the opponent, the victim, how many people have you talked about? Who have you talked to about this? And if you list a lot of names, they might go talk to those people. And if those people had a bad opinion of what you did, they might have to come testify against you. So just don't do that. Don't go in the ER and talk to everybody. But talk to the people you need to talk to feel better, to cope with the situation. It's a touchy-feely thing, I know, but it's also about your case defense. You are the most important actor in the defense of a case. So you have to be strong, confident, ready to rock. So you can talk to all these people in a privileged manner. So these pictures I took at the Chicago Millennium Park Cancer Survivors Garden. And it seems, disingenuous to compare cancer, malpractice litigation. Some are at risk of death, some are at risk of, a career impact. But your body doesn't know the difference. Your body will be completely stressed by either. And I tell you, some folks who've been through malpractice litigation might say, I would have rather had cancer. Don't call the patient, and don't call the patient's lawyer. See, when you don't take a chill and you get into that state where you're like, I can fix this, it leads to some pretty imprudent actions. You'll be tempted to point fingers. If it's like that case where I said you sent them upstairs and this is really like radiology or surgery or the floors problem, you will be tempted to immediately say, no, it was Dr. Smith, it was Dr. So-and-so, this is BS, talk to radiology, don't talk to me. We can make those arguments. It will take a long time, but we have to be very careful and diligent about making those arguments. If we immediately start blaming the other clinicians in the room, a jury just hears blame. They don't hear who's blaming who. They hear suspicious talk. If one physician comes in and says it's really Dr. Jones' fault, and the other one says no, it's really Dr. Smith's fault, the jury's going to say, well, it's somebody's fault, and we're just going to take a shortcut and give them $20 million, and y'all figure it out. So we have to be very careful about blaming others. And then we talked about the record. I understand a real frustration that, when you get sued, you can't immediately go to the best resource you have to figure out what's this all about. But it could cause a problem. Somebody could ask, did you change the record? Somebody could ask, did you violate HIPAA? Hospitals can be very sensitive to this. Oftentimes I get a call of, hey, so-and-so went back in a record, trying to learn from a really bad case that we all knew about. and the hospital's really upset. So you got to be careful with that stuff. Also, I talked about don't text, don't tweet. So text is a big one. I've had problems with. Got a question? Yeah. Yeah, that's a great question, and it bears further detail. So the question is, well, what if it's a case where we need to go back and QI it? What if there's an RCA? Those privilege processes are fine, and in fact are probably a great idea for everybody to learn from this case. You can advocate for that. If you say, you know what, I might get sued on this case, I'm worried about it, I think we can all learn from it. Medical director, can we run it through QI? If it's not going through one of those processes, though, the key is, even if you could get in the medical record, it's a limited view. What we're going to give you later on is not only your medical record, but everybody's medical record. You will get a very clear picture of what happened to this patient, and we will rely on you to give us that first review. Finally, texting and tweeting can get you in trouble, and texting is a big one. When was the last time you called a social acquaintance on the phone, like with their numbers and like talked to them? No, you text them. I've been texting Marco Polo and my wife. If she called me, I would think like the house must be on fire. You don't call anybody anymore. You text. And so I see that dynamic with some of the younger generation of physicians and clinicians. They will get sued and they text everybody. And they'll text their medical director. That is not a privileged conversation. That can come up in litigation. So take a chill. This fella is a good illustration of that. He was a PCP. He got sued, and he didn't take my advice. And he blogged all about it, all about the experience. He got into the trial, and he talks about it, even to such an extent that like people who followed him were like, "Hey, buddy, this is probably a bad idea." And then on the second day, he's talking about it. And then on the witness stand, the plaintiff attorney says, "So, do you have a Twitter account about you being the flea?" And he had to answer honestly, and that was it. Case was quickly settled because the things he said were not helpful. He had all these nasty things about the jury. He wrote just this ridiculously nasty thing about the plaintiff attorney, and just this disrespect for the system and in the kinds of the ways that you write on Twitter or text, it's going to be a problem. And later on he said, everybody thinks I'm a fool, but you know what? I thought I had it all figured out, but then the trial approached, and I just lost my mind. So again, this is about taking responsibility for your reaction to the situation and then proceeding prudently instead of anxiously. A couple more quick things before we get into the mock deposition. A very important point. A lot of clinicians think they can't rock the boat. That Dusty has hired an attorney and the insurance company is confident in this attorney and they're just going to tell me what to do and I'll just chill. No, you've got to take ownership. This is your career. These people get paid either way. And if you aren't happy with your lawyer, tell somebody. If you want your lawyer to call you every week and say nothing has happened, set that expectation. If you want to be kind of left alone and maybe get an update every 120 days, set that expectation. You can do that, and you should do that. Because if you don't, a lot of times I'll have to come in and pick up the pieces where the relationship is completely soured, the physician's used up, now we got to settle the case, and I got to change the lawyers. I will fire a lawyer in a second. They're all doing fine, these local lawyers. So at any time you're not comfortable with the attorney, speak up. I can fire a lawyer. I can't fire the defendant. I can't trade out the defendant. You might wish we could, but we can change the lawyer. So speak up. Complain if you're not happy. Another point I want to make real quick is, you will see friendliness. You will see smiles. You will see me and the local attorney paddling around with the plaintiff attorney. At least the good plaintiff's attorneys, we do. You'll see me being very friendly with the deposition deponent. That sort of collegiality is a professional ethic of good lawyers. It does not mean that your lawyer's not doing a good job for you. And in fact, it probably means the opposite. And I know what you're thinking. A lot of times you think, no, I want a pit bull. I want a deranged, Michael Cohen-esque lawyer who's just going to call people and cuss them out and they'll all go away. That is not how things work in the real world. In fact, I got a letter once that said, my defense attorney, I think, is way too chummy with the plaintiff attorney. And I think they're all in this together and conspiring against me. And this is just not going well. I want a bulldog. I want somebody to fight for my rights. And then 9 days later, he said, oh, wait a minute. They actually got a good resolution. Forget what I said, because the defense attorney explained to me that her closeness with the plaintiff attorney is how they worked out a good resolution on this case. If you're an absolute bulldog and the plaintiff is as well, that might work for a second. But over a very long litigation lifespan, the judge, the jury, everybody's going to get turned off, and you will get a much better resolution if the lawyers are working together to create a good resolution, as well as possibly just defend the heck out of you. But that's what lawyers are there for, to work through these problems in a collegial, professional manner for the good of their clients and not just scream at each other. If they did, why would you even need lawyers? Well, some would probably say we don't need them at all. So you get sued. You got an attorney. Now what are we going to do? Very quickly, we have to answer the complaint. This is that short timeline thing I told you about. In some states, you only have 20 days. So you got to get the complaint, the one with all the nasty things about you. Got to get a quick answer out. Now, sometimes there's a misconception. This is where we're going to win. This is where we're going to fight, make our arguments. But no, it's just, stock complaint allegations and then stock answers. We deny everything. These are just placeholders. The real investigation, development of the case comes in discovery. We'll get reams of files of employment records, work records, medical records that you'll have tons of medical. If you want to review the medical record, we will have tons of medical records for you to review. This takes a very long time, months. And then we get into the depositions. With that, we want to start kind of preparing the scene here for my deposition